ensayas rápido, no te sabes poner pie. Esa es una que lo ensayas rápido, no te sabes poner pie. Esa es una que
Welcome back to Civil Discourse Now. I'm Mark Small.
Good afternoon, Mark. I'm Paul Ogden, co-host. Switch things up on you.
Well, you just kind of threw me off there, Paul. This is May 19, 2012. Our guest today is Tammy Moon. We are podcasting from 1001 Restaurant Bar at 1001 Broad Ripple Avenue.
Quite a coincidence, actually.
Yes. And it's a beautiful day in Broad Ripple. It's also the day that the Broad Ripple Art Fair is being held. Actually, 2 days. Broad Ripple Art Fair is held on Saturday and Sunday. It's supposed to be gorgeous weather for both days. People who live in Broad Ripple love the art fair, but also know that it means that the streets are fairly congested. A lot of traffic because a lot of people are here seeing the art fair. We are here discussing bullying. And Tammy Moon is CEO and president of Bully Prevention Alliance, which is a not-for-profit here in Indiana. We were talking between segments just now about statutes here in Indiana. There is an anti-bullying statute under Indiana Code Section 20-33-8(1) and in the following sections. And it sounds like it's really gutsy because it says discipline rules prohibiting bullying are required, and so you've got to have rules against bullying in your school. But then it comes down to 20-33-8-13.5 section D says this section may not be construed to give rise to a cause of action against a person or school corporation based on an allegation of noncompliance with this section. Non-compliance with this section may not be used as evidence against a school corporation in a cause of action. Okay, now let's get clear about one thing. People out there are saying, well, lawyers make too much money, and people are out there just making money off of stuff, and off of all of these lawsuits, now why should the school corporation have to suffer? The only way that school corporations are going to suffer is if they're held accountable because some kid dies because of the ineptitude of someone like a school corporation superintendent who says to a school board member, we're not going to conduct an investigation of this. School board members can't make us investigate. I've called in the assistant principals and the deans and everybody to tell them that we won't tolerate this, so you just leave us alone. If you don't have damages at law where a school corporation or an individual has to pay damages, then you don't have an effective means of enforcement of the law because there's nothing else. This is not a criminal statute.
No.
So if the school fails, and you can't put a school in jail. It's an entity or a building. So if the school fails to comply, or it has a provision in the code that says, well, bullying is not allowed unless it's varsity letter scholars or athletes who are doing it. If they make exceptions or it's a bad rule, there's no accountability.
Under the educational statute, right, there is no accountability. The only other way you could do it is if, like, for example, you have, I'm going to throw this one out there. If you have a student who is physically battered by a staff member or another student, you can press criminal charges. So the only way to really go with this, and this is what they did in 2011 with the 21 bills, is it has to follow within the civil, the criminal, and the educational statutes. And then you have people going, well, how do we press charges on them? You can't press charges on bullying because we have no criminal law against bullying. No, you may not, but this again is what we do when we're in, working in law. We say, okay, What was the physical act that was done?
Well, and if it's a physical act that's done like a battery,
Yeah.
well, I'm charging with a battery.
Yeah.
But the problem is, there's
If
no.
it's harassment, you can charge them with harassment. But get
There
a
is
case.
there's no criminal
Right,
charge of
right,
harassment.
right, that's civil.
Yeah, but I guess my point is, if you have a teacher who stands by and does nothing,
That's neglect.
and the child, a child is struck, or a child is emotionally driven to the point of suicide, and that the school was responsible because the school took action in Kirk Smiley's son's case. The school expelled his son for defending himself, and his son was despondent over that. The school was part of the mechanism by which that child was driven to suicide.
Right.
And so not only is the school not held accountable for negligence in oversight of the children there, it was a mechanism whereby that child suffered and died.
Right, and if we were to look at laws that are outside in the regular business world, away from our educational statutes, that would not have happened without consequence. Like if it was an employment, workplace employment.
Well, I don't know that you
so-
can say that anymore. And forgive me if I'm overstating it, but I believe that with the Roberts Court striking back against damages suits so heavily, on the one hand, it sounds like, well, gosh, plaintiffs don't have their big payday on a lawsuit, so that the woman who spilled the scalding drink in her lap at McDonald's, she had surgery on that. She suffered major injuries. Well, those big paydays are gone. So what? Well, those aren't necessarily big paydays.
It's not about payday, it's holding them accountable regardless. And that's what I'm saying, so like we have workplace, we have laws in place pertaining to workplace harassment, and, they actually termed it workplace bullying. And if we as adults can go into a workplace and be protected from such behavior, from our employers, our bosses, well, why not kids? I ask this question because kids are going to school, that's their workplace. And their bosses are like their teachers. And their employers or their co-workers are like their peers. But that statute, with that one clause, prevents anything from being done.
I'm not sure what the laws are in workplace harassment, or do we have that?
Yeah.
I think also a lot of the harassment in workplace statutes have to do with suspect classes.
Right.
Because
that would be a little bit different. Because your race,
gender,
But
religion.
that's also stuff that's being done right now to these kids in bullying situations. People are being taunted because of their gender, because of their race, because of a special need.
Here's the problem. Those lawsuits, those statutes exist, and lawsuits can be brought. But if the courts are overturning the lawsuits, then the effectiveness, and that happens a lot in 1983 actions.
Civil rights actions in 1983
Right.
went into court extremely difficult.
And to explain to the people watching, a 1983 action is 24 U.S.C. 1942.
42.
That's
No, it's
42.
42.
42 U.S.C. section 1983. I was a little dyslexic on that. Is a civil rights statute.
Right.
It says that a person is entitled to damages and can bring action for anyone acting under color or title of state law who deprives them of their civil rights.
Right.
And that's been the means by which people have sued for discrimination, and it extended people's rights, because when people started having to pay money because they were engaging in acts of discrimination or harassment, then all of a sudden those levels went down.
Right.
But then go ahead.
Well, I remember a state legislator, we were talking about actually the Barnes case, and there was a hearing on it. I don't want to get into that, but but he said, well, one of the remedies, no, you can just go to the federal court and file a 1983 action. The attorney, he was an attorney, but he didn't practice civil rights law. They dismiss like 90% of those cases on summary judgment. You're never going to get your day in court.
Right.
And summary,
Very difficult.
Right.
Summary judgment means that, yeah, anybody can file a lawsuit for anything.
Right.
That doesn't mean you get to go to a jury trial.
Right.
First of all, if I sue Paul because he's wearing a blue shirt, then Paul's probably going to file what's called a 12b6 motion. It's a rule that says you've got it. There's no basis in the law for my having filed suit against him for wearing a blue shirt. The second hurdle is summary judgment,
Right.
where the defendant would argue that there's no question of fact, but that the law is on their side. So you don't even get to argue your facts to the court. And so a lot of the cases are thrown out because there's no dispute of the facts, and they're arguing the law doesn't constitute.
Well, and I would disagree because I've had a problem with how federal courts have enforced summary judgment. It becomes you pile your evidence on the table and they pile their evidence on the table and they decide which is the better case.
But
that's not the way
to.
it's supposed to work.
No, it's not.
It's not supposed to work that way. And in state court, it doesn't work that way nearly as much as it does in federal court.
In summary judgment is supposed to be granted only if there's no material issue of fact. If the plaintiff raises a material issue of fact, then it must go to the jury. But that's where the federal courts have really tightened up because of 8 years of George W. Bush,
Right.
4 years of George H.W. Bush, and 8 years of Ronald Reagan, and that's a very...
Well, I think it predated those.
One thing that I am glad that you guys brought up is the federal courts, because what also I discovered between evaluating the federal and the state statutes is while our state statutes and many other state statutes fail to be able to give us all the rights that these kids need and are afforded, there are many federal statutes and that do, and that also open the door for the ability for states to put into place those compliance laws. If it's there and available and already in the federal statutes, then the state can do it. One of the federal statutes, and I don't have the code actually written here in front of me at the moment, but I do believe it is under 42. One of the federal statutes actually specifically states that if the school district is not complying with the state's laws that have been set up under education, then the U.S. Attorney General can actually take over, and the U.S. Attorney General can actually file the lawsuit against the school district for the victims.
Has that ever happened that you're aware of?
There is one.
I'm talking about here in Indiana.
Here in Indiana, no. But there are a couple cases that I've already suggested that need to go over to Zeller already.
Who is the Attorney General?
Who is the Attorney General, to have him look at
Indiana
it, to
State
go
Attorney
up.
General.
Yeah, to have him look at it and then make the recommendation to send that over to the U.S. Attorney General, because, and those cases actually come up in Fort Wayne. And you know, I said, you know, those seriously need to be looked at. But they're also, the interesting thing is...
Just a second. Hold that thought. We'll be right back. We're at the end of this segment, and we'll be coming back for our final segment here in just a couple minutes.